My name is Tim Wilson. I'm a patent attorney here at Dehns, and I work mainly with inventions in the fields of software and electronics. The subject of today's webinar is artificial intelligence and patents. As I go through, please feel free to ask any questions that you might have using the Q&A function at the bottom of the screen, and I'll try to address those during a Q&A session at the end, or if we run out of time, then I will try and respond by email. So as we begin, I'll give you a moment to read the following. It's quite amusing, isn't it? That was taken from a recent feature article in the Guardian newspaper, and it was written entirely by an artificial intelligence program called GPT-3. Not just that, but a full-length feature article. It's worth a read if you have time. Ironically, the subject was why humans have nothing to fear from AI. I say ironic because I suspect I'm not alone in having found the article just slightly less than reassuring, given its implications for the future of work, and perhaps not just journalism, and even for the future of human creativity itself, as well as much more besides. But I hope we can also all agree that the progress made by AI in the last few years has been truly spectacular, and it clearly has the potential to benefit society hugely. So today I'd like to provide a brief introduction to AI technology. It may be familiar to many of you, but hopefully it's worth recapping, as well as then to patents in general, before moving on to consider how the two, patents and AI, can work together to provide some really great opportunities, as well as a few challenges along the way. What do we mean by AI? Artificial intelligence, of course. First, let's think where AI can be found today. It's around us in many areas of life, both seen and unseen. Just put a few examples here. Self-driving cars have obviously been in the news a lot recently. Many of you may have a voice recognition on an Alexa or Google Home or Siri app. It's also being used behind the scenes, perhaps in robotics, in industrial settings, in drug discovery, in data mining, in language translation, where there's quite a long history there. And there are many more examples as well. The term artificial intelligence has been used over many decades and has had quite sort of broad application from intelligent system agents and all sorts of other software. These days, we're meaning particularly machine learning technologies. And those machine learning can do quite a number of interesting things. There's some of the main capabilities here are classifying. You may have seen examples where people are looking at pictures of dogs or cats, and you can train with a labeled set of, a person has labeled pictures of each, and the computer can learn then to make those detections itself. And Google has some image searching that can do quite impressive things for recognizing images, but all sorts of classification problems. There's also decision making, where you train a system to give it rewards to help it make better decisions. For example, when playing a game like chess, or the game of Go was in the news when Google DeepMind recently beat the world's best Go players. But many other decision problems are also being used in AI. Discovering patterns in data, that unsupervised learning, that is sometimes called, where a person hasn't trained it, but it just looks at data and spots anomalies or spots trends and patterns, can be used for all sorts of different data analysis tasks. And then creativity, I mentioned it briefly we started with that article. That's a photo on the screen that was generated by an artificial intelligence system based on lots of other photos it's seen. It made a person. She doesn't really exist. How does it do it? Well, a key component of most learning systems these days are artificial neural networks, mimicking the human brain, although it's important to say that we're not here thinking about generalized AI where computers are trying to become human brains with minds of their own. It's a more simple analogy where you weight different connections between units called neurons, and it's an analogy to the way the human brain is structured. And you feed data in and it can learn to weight it appropriately based on feedback, and then you can use that to do some of the tasks I mentioned previously. And they've been around for a long time, but they're really coming into their own now. And they're built into more complicated systems with many layers, often referred to as deep learning, where you have multiple layers. Here's an example of looking at an image, a system that's been trained on images of vehicles and roads to identify features in the scene, and to be able to help in self-driving technology. And why is it all taking off now? As I say, some of it's been around since the 1960s or even earlier, but there's been a real synergy now between data, big data, lots of memory and capacity, and lots of life being digitized, inexpensive sensors gathering data all the time, more powerful algorithms that have been developed for sort of in the academia and in the industry to sort through that data. And then a big one is computing power, that the computers of 30 or 40 years ago just couldn't crunch that volume of data, but now we can. So moving on to think about patents very briefly. Patents are part of the intellectual property system, which is a body of law that countries have developed to reward and incentivize creativity. And there's a number of different areas of intellectual property protection available. You may be familiar with some or all of them: copyright, designs, trademarks, patents, and then confidentiality or know-how or trade secrets. And we're thinking today particularly about patents, although some of the others, particularly copyright and confidentiality, can also be of relevance to artificial intelligence systems and how they can be protected. Patents in particular have a long history, dating back 500 years or more. Initially, got a picture of some stained glass window there. They protected chemical compositions with glass. In Italy was one of the earliest patents granted as a monopoly right to encourage development and innovation, or the bringing of new ideas to the market. Patents protect new solutions to technical problems. They're for the fields of engineering and science rather than art, for example, where copyright is more relevant. And you have to apply for patents. Unlike copyright, there's an application process and fees are payable to governments, who then decide whether or not your invention is worth having a time-limited monopoly where you are allowed to commercialize it in that country without competition. And it's a powerful right, so it comes with some reasonably high hurdles for obtaining it. Your invention must be new, never disclosed before to the public, and it must involve an inventive step, not be obvious over what's been done before. There are also some exclusions in some countries to what sort of things can be patented. I'll mention some of the relevant ones of those in a few moments. So patents and artificial intelligence, unsurprisingly, I'm focusing on the intersection of those, being a patent attorney who works with AI and software. And it presents a lot of opportunities. There's a long history of patents and AI. Here's an example of a patent dating back to 1962 for a learning machine. That's in many ways not that dissimilar from some of the learning systems that we have today, only without the big data and without the processing power that we now have, that have made it really take off. Reasons to patent AI. Why would you think of patenting AI systems? Some of these are applicable to patents generally, but it's particularly interesting, and why we've got a topic of webinar on it today, AI is booming. It's expanding rapidly across lots of areas of engineering and science and technology. So there's lots of opportunity for innovation, for development, and for companies to move ahead. And patents can help to incentivize and add value to a business and attract investment. They may also be helpful for secondary factors like marketing to talk about patented technology. And they can also be useful behind the scenes to help underpin licensing. If you have know-how, it's harder to license that because it's hard to define. But if you have a patent, then what you're offering is a bit more clearly defined. As I say, it can deter competitors from taking your ideas without having to have done the hard work of developing them themselves. So it can give you a competitive advantage for a period of years. Also, as well as being used in that more aggressive stance, they can be used defensively. And many companies and many of my clients obtain patents not with a primary aim of suing other people for infringement, but as well as the licensing and investment ideas, to build a defense in case they're ever threatened by a competitor. Then there may be some ability to deter that through a counter threat or through opportunities for cross-licensing. So they can be a useful defensive asset to have as well. Thinking about AI more specifically, what aspects might people want to patent? Well, you might want to patent some fundamental new AI algorithms and models of new math. You might want to patent more the idea, the application of a particular AI to a particular problem or context, for example, language translation or drug discovery. Or you might want to protect aspects about the training of an AI model, for example, a particular data set of maybe medical patients, or a method of pre-processing data to clean it before you train a model with it. Now, some of these ideas may be patentable in some countries, and others may not be. Unfortunately, the national patent offices haven't taken a harmonized approach around the world, so it does get a little bit more complex, and I'll look at some of those issues in a moment. As well as being different in different countries, the rules on what can be patented and what can't evolve over time, and in some countries they're evolving quite fast. So it makes it a bit of a tricky one to be clear and definitive about. And also, because it's all relatively recent, the explosion of interest in AI, there hasn't been time for a lot of case law or a lot of precedent through court decisions to have built up. So the situation is dynamic and fluid. But I'll have a look in a moment a bit more at the situation as it stands today in Europe at the European Patent Office and in the US. But just in brief, in Europe, there are requirements that specific technical applications or implementations of AI are patentable. In the United States, non-abstract AI innovations are potentially patentable. China, rather similar to in Europe, technical AI innovations, potentially considered in combination with algorithm or business features as well, are potentially patentable. Japan is more permissive generally for software innovations, but still has a strong requirement for inventiveness, and also that you describe the invention clearly enough. So in general, a message to take away is that it is possible to get patent protection on AI in the right situations. There's sometimes been a misconception that software can't be patented at all, and that's absolutely not the case. But it's not a complete free-for-all either. It requires some careful thought about what can and can't be protected. So looking at the European Patent Office first in a little bit more detail, Europe has quite a long history of considering software inventions and has developed some fairly detailed guidelines and approaches to what can and can't be patented in the field of software generally. And their approach is that artificial intelligence or machine learning software is treated essentially the same as any other software invention. And the long established approach is that it must claim a technical solution to a technical problem. That obviously leads on to the question, well, what is a technical problem? When is AI solving a technical problem, and when is it solving a non-technical problem? Well, a technical problem could be a problem outside the computer. That's most often perhaps going to be the case. But you could be using AI to control a machine, for example, a car. That would be seen as a technical problem context because it's an engineering problem. Processing images, perhaps taken from a camera to enhance the contrast in the image, that is also seen as a technical problem. You're processing image data and pixels to improve the image. That's seen as technical. What isn't technical? Things that are more in the field of business or commerce or administration. So, for example, if you had an AI system that detected plagiarism in essays written by students at university where they copied bits of other people's work, that as a context for the AI problem would be seen as a non-technical context. Similarly, for example, categorizing documents that have been scanned in a workplace into different case files or different document types, that would be seen as a business administration problem, a task that a human might have done in the past, but you're using AI to do faster or better, but the problem itself isn't inherently seen as technical. There is another area where a technical problem might arise, which is inside the computer that's running the software. So if you make a better computer, as the European Patent Office would describe it, for example, if you're using AI to manage power within a computer system, that could be seen as making it a better computer system. Or if you're using it to, for example, detect computer viruses or other attacks, that could be a technical process within the computer. But new general AI methods and algorithms, pure maths of general applicability, are likely to be excluded from patentability as mathematical methods. Also, data sets themselves, mere data sets, are likely to be excluded from patentability. Even if you've put a lot of thought and care into how you select the data, it's still seen as non-technical inherently. But if you start processing that data or generating it from a technical source, then like sensors, or if you pre-process it in a particular way, that could be okay and patentable if it's deemed a technical process. So in Europe, at least, AI inventions that are of a more mathematical nature need to be tied to a specific technical application or purpose, or they need to be tied to a particular computer hardware or system. If those conditions are met of specific technical applications or implementations, then it's promising. If it's pure mathematical innovation, a new AI model, then that's less likely to go ahead easily in Europe. The United States doesn't have those same exclusions in law against patenting software or mathematics that are present in the law in Europe. But there have been Supreme Court decisions a few years ago that established that you can't patent an abstract idea. And that's caused a bit of confusion because trying to determine what exactly is abstract hasn't been straightforward for the Patent Office or for patent practitioners and others. But there are some clearer examples of things that are abstract and haven't been patentable, and also many which have been patented. In general, if you have a novel algorithm implemented on conventional hardware, that may struggle. So again, similar in a way to Europe, if it's a mathematical innovation, fundamentally that may struggle. But if it's tied to a particular machine, or if it's doing a technical operation, then it's more likely to be patentable. So in practice, if you're going to meet the conditions of the European Patent Office, then you're probably in reasonable condition for the United States Patent Office as well. There may be some things that may be patentable in the US, but may struggle in Europe, and there may be some the other way around as well. But the conditions are somewhat similar in practice. So to put it a bit more concrete examples of what may be patentable, the situation of an invention that adapts a machine learning technique to a specific technical problem, I've said, is likely to be patentable in many countries. So, for example, that could be a system, as we've got illustrated here, for discriminating between exposure levels and motion artifacts in smartphone camera images. So if you take a series of photos and you want to blend them into a panoramic scene, it's important for the phone to understand whether there are artifacts due to motion in the image or whether there are changes of lighting. And this image was taken from a patent application that used AI to work out and classify image artifacts as either exposure or motion. That's the sort of technical problem that's likely to be deemed patentable subject matter, as long as it also meets those criteria of being new and inventive over what's been published previously. Another example, data pre-processing or potentially post-processing. So for example, if you had a MRI scan image data and you were training a machine learning system to detect particular disease, if there's a way of filtering that image data, of enhancing it digitally to improve either the efficiency of the training process or possibly the quality of the recognition when presented with actual sample data, then those methods of pre-processing could potentially be patentable. Another example, I mentioned about hardware. If you develop new hardware architectures for example, implementing a neural network efficiently, a massively parallel processing system, perhaps you have a hardware memory manager that allows big data to be processed efficiently on an FPGA platform for neural networks, handling large amounts of data in a new way. That sort of technology would make it a better machine in the language of the European Patent Office, and is potentially patentable as an engineering innovation. So we've seen some of the opportunities that the patent system can provide for protecting artificial intelligence developments. But I've also touched on some of the challenges, and I'll say a little bit more about some of those now. So as I've mentioned, in the US, Europe, China, and potentially elsewhere, there are some things that aren't likely to be patentable. The mere idea of applying machine learning to a particular problem without any technical innovation is unlikely to be patentable. So if you have the idea of doing something that people had to do before, for example, looking at microscope slides and trying to identify particular specimens or count the number of a particular type of compound or organism, and you think we could teach a learning system to do that faster and on larger volumes of data than a person could, but you take an off-the-shelf machine learning system and you train it using relatively standard training techniques, the fact that you're applying it to a new problem that it hasn't been used on before isn't likely to be sufficient to meet the thresholds for patentability, because it's automating what people did before isn't going to be seen as a technical innovation in most countries that meets the inventive step requirements. Similarly, I mentioned that if you've developed a new fundamental mathematical model or technique, then at present that's going to be difficult to patent as such in many countries as well. There are some other challenges when it comes to the actual process of applying for a patent. So actually identifying where the inventive contribution lies is a challenge potentially that the patent attorney and the inventors will need to work through. AI solutions are often developed with a fair amount of trial and error and improvement, and they can arise with a combination of clever selection of training data, intelligent pre-processing of the data, the choice of the model and many parameters in how the model is configured, potentially some post-processing, and maybe even the choice of hardware that's it's running on. And all of those can be working together to achieve the solution to some problem. But a patent to be powerful and useful commercially, ideally needs to try and hone in on the real heart of the invention and distill where the essential new concept and inventive step lies amongst those different features, and disentangling that isn't always straightforward. Also, it's in the nature of some machine learning approaches that it can be difficult to work out why a computer or a model has learnt to solve a problem. Actually trying to extract meaning from a trained model is a challenge today. So then trying to write a description of how it works is sometimes a challenge. And that feeds into the need, as I've mentioned, to demonstrate in the patent that the innovation solves a specific technical problem or works in a technical way, not just an abstract idea. It's also important when writing the patent to define the invention clearly and precisely. And the field of AI, like many others, has got a lot of technical jargon and buzzwords. I've listed a few examples there. There are many more you can probably think of, some of which do have established meanings, others of which are likely to be seen as somewhat imprecise by a patent examiner and can't easily be used in a patent claim to limit the scope of the invention. So the patent attorney needs to work with the inventors to work out the best way of describing it in accurate technical terms. And then the last point I've put on the slide here is about the need to prove that the invention actually works. Patent applications need to meet a requirement known as having an enabling disclosure. You can't simply assert in a patent that you've solved some problem without saying how you've done it. You need to give enough information that when the patent expires, the invention has been put into the public domain so that others can use it. And that requirement is quite a challenge in some cases for artificial intelligence inventions, because often the data, the training data that was put into the model is key to getting a model that actually works. But often there's issues, practical issues or legal issues to including the data in a patent application. There may be confidentiality of patients, for example, in a medical context, or just the volume of data. It's not feasible to provide it. So there's a challenge there to work through as how much information to give to demonstrate how the model works and that it does work, and to enable others to exploit it in future. So those are some challenges. They're not insurmountable, of course, but they need to be noted and worked through carefully. There may also be some commercial considerations. Even once you've obtained your patent, it's worth thinking, how would it be enforced? For example, it may be practically hard to work out how a potential infringement actually works. If it's running on the cloud, for example, a Netflix recommendation engine, for example, I don't know how that works, and I can't just find out. It's on their servers. So if you have a competitor who seems to be achieving similar things to your patented invention, to work out how they're doing it isn't going to be straightforward potentially. It can also, even once you've accessed a trained system from a competitor, be hard to work out how it was trained. You can't access the training data necessarily, and just looking at the weights in a model isn't going to be very easy to work out what it's really doing inside. There can also be some territorial challenges. Patents are are granted for particular countries, but as with software and cloud-based software in general, servers can be hosted anywhere potentially, and that can raise some issues about what jurisdictions and territories patents need to cover. All of these concerns can be mitigated and thought about and addressed through various things, such as careful patent drafting, getting the claim scope correct, and also considering strategically a mix of protecting innovations through patents, but also through trade secrets or confidential information, and trying to think intelligently about what to patent, which discloses it into the public domain ultimately, and what to keep as a secret. For example, the training data I mentioned before may well be something that one wants to keep confidential. That can be in tension with the need to show that the invention works with enough detail in the patent application. But these are things that can be thought about and worked through, but they need to be given some careful consideration. Finally, a presentation on patents and artificial intelligence wouldn't be complete without thinking of the future impact of AI on inventions and patents, turning it round a little bit. If you recall the apparent creativity shown by the AI system that wrote that article for the Guardian newspaper that I started with, it's clear from that and many other areas that AI is achieving things in terms of creativity that potentially can start to rival what humans are doing. And there are technical fields such as drug discovery or product design, where AI is very much already coming up with innovations that potentially are similar to what a human inventor might have come up with in the past. And so that's raised the interesting question of, should a patent name a computer or an AI system as an inventor, potentially in combination with human inventors, or maybe even as the sole inventor? Now, that was actually tested a year or so ago by some patent applications that did exactly that. They named an AI system called Dehns as an inventor, and those were recently all rejected by the UK, the United States, and the European Patent Office on the grounds that they didn't properly name a human inventor. But they have raised the topic for discussion, and there's a lot of interesting legal and potentially commercial and maybe ethical decisions ultimately that will flow from that. But they're probably ones that we'll need to keep an eye on for the future rather than being able to resolve them today. But an interesting area to bear in mind and think about. So to sum up, artificial intelligence, clearly a really exciting field, lots of potential for innovation. Patents can help to further that innovation through encouraging investment in businesses and fostering technology development through the time-limited monopolies that they offer. There are some challenges in the process along the way, so patents need to be used carefully and strategically to maximize their benefits and to strike a balance between the costs involved and the rewards that they give. Yeah, I hope that's been helpful in showing some of the overlap and the issues that arise when looking at patents and artificial intelligence. So I'd now like to open the floor for some questions and answers. Please type any questions you may have into the box at the bottom of the screen, and I will just have a look at those now. So first question we've got in: if I develop a machine learning system that has a wide range of potential uses, is there any way that I can protect it through the patent system? That's a good question. As I was saying, if the innovation lies in fundamental new algorithm or at a sort of mathematical level, that's likely to be challenging, being deemed abstract in the United States and a mathematical method in Europe and some other countries as well. but you could look at the implementation of that system with particular hardware or a computer system. What is it that makes it better? Why would you want to protect it? Why is it useful commercially? Does it run faster or with less memory requirement or more efficiently than a previous systems? In which case, those interactions with the system it runs on may be seen as technical and helpful for protecting it. Or if it does have a wide range of uses, it's worth considering the approach of trying to identify those and explore them, and potentially list some or all of them in a patent application, and to put patent claims into the different combinations of using that new system for a particular problem, particularly if it's a fundamentally technical problem in science or engineering. Those could be useful in their own right, or if there's some synergy for why that model is particularly good in a particular context. And that could help to avoid it seeming like a purely abstract mathematical invention. So we've got another question here. A lot of the AI tools available to engineers and researchers building robotic systems are open source. What impact does that have on the patentability of these systems? It's a really good question, and one that comes up in a lot of software, as well as not just artificial intelligence. And it can be an issue. Open source licenses are not all the same, and so it's important to look at the details of individual licenses as to what they allow in terms of requirements to publish, if you have a sort of copyleft type requirements, whether they put restrictions on the use of it. Fundamentally, though, when we're trying to patent an innovation, we try to describe it at a higher conceptual level than the actual software implementation, the code that's used. The patents don't typically include source code at that level. They're more at the level of flowcharts and the software architecture at a sort of high level. And so that's generally the approach we would try and take, is to see, can we describe the invention at a sufficiently high and general level that we're not really looking at the nuts and bolts of the source code that was used, so that they could be implemented in many different ways, and they could be implemented using open source systems, and it's fine to mention that as a way of doing it to meet that requirement for enablement. But if it could also be implemented through a proprietary coded approach, then that would be a good indicator that you're not so likely to be in conflict with any open source licenses. Another question, what are non-abstract AI innovations defined as? Are there any examples? So yeah, the term of abstract has come up from United States case law. I'm not a US patent attorney, but I do quite a lot of work with US patent attorneys and with the US patent system. My understanding is that it's not that clear cut to anyone really exactly where the boundary lies. To be fair, it's not that clear cut in Europe either as to where technical and non-technical fall. But hopefully some of the examples I've given of systems where you've got some technical interaction with the real world, or technical interaction with some novel hardware or some novel sort of processing architecture, those are likely to be seen as non-abstract for the US as well. Another question regarding patenting an AI method. Can you prove that a competitor is using your specific already patented algorithm? This seems like a challenge that would want people to avoid patenting AI algorithms. Yeah, so it's a good point. And one that I mentioned, one of my later slides, I think, after the question came in, so maybe that's been partly answered already. But one of the things I didn't mention is that although it can, as a practical matter, be difficult or impossible to get access to algorithms that are being hosted on remote servers, And there are legal methods that can be used to do that. So if you have reasonable grounds to suspect an infringement, you can potentially go to the court and they can issue an order for the potential infringer to reveal how their system does work. So that sort of discovery or disclosure approach can be used to try and work it out. Of course, there are also many AI systems which aren't cloud hosted. So a self-driving car, for example, it's not feasible for the software with current communication technologies anyway to be hosted remotely, because your car has to work when it's offline as well. So there, it's more straightforward to try and reverse engineer and see how things are working. How does the Patent Office ensure that the training data used by the end product fulfills license agreements? How do they make sure they do not train their models with data or images gathered from the internet without written permission? So yes, as I mentioned, so often the sensitivity around training data, and that can be a little bit tricky to know how to use it. There are some public training data available in some areas, but obviously some is commercially sensitive. In that case, we have to describe the invention in a way that doesn't rely on providing the training data in the patent. We can describe the type of data in general terms, how it was collected, sort of how it was pre-processed, and then give examples of the output of the system to prove that it does work, but actually keeping the data as confidential know-how. The Patent Office is unlikely to directly look at licensing issues regarding the training data. They assume that what you've given them can be published, and will do so after a year and a half when the patent application is made public. When would you choose to keep algorithms confidential instead of seeking patent protection? It's a really good question. There are a number of factors to consider there. One is how easily they could be discovered. If you can run them on your own servers, then obviously that it's much more feasible to keep them confidential, and that could well be a good approach. There are other factors to consider as well. Cost being one. Patent protection is relatively costly to apply for and obtain. So you simply, if you're developing large numbers of algorithms, it may not be feasible commercially to try and protect all of them. So a careful balance and decision as to what to protect and what to keep confidential, and potentially what to publish, needs to be made there. Maybe even the size of the company. If it's just a few individuals, then it's more realistic to keep things as in-house trade secrets. For larger organizations where employees are coming and going, then as a practical matter, information can leak out, and so it may be harder to rely on trade secrets as in practice. Can I elaborate on the distinction between replacing something humans did manually and a technical effect? It seems in a lot of cases these would overlap, e.g. identifying new drug candidate molecules. Yeah, good point. So that is starting to be more relevant, as I was saying, when computers are coming closer to what inventors used to do. I think the case law at the European Patent Office was looking a bit earlier at business method inventions, where software was being used to automate the filling in of an accountancy tax return, for example, and it was something that a human would have done before, and then software was being used to do that. If it's the mere automation of a human business process or a human mental thought process, something that you could feasibly work out with pen and paper in reasonable time, and you've just programmed a computer to do it faster, then that's unlikely to be seen as having a technical inventive step over what was done before. If it is a more inherently technical process, then certainly that can be. So a machine that does what a human lab technician used to do could certainly be patentable as an engineering system, and the same potentially could apply to software. That if you've got software that's doing something that is inherently technical, then as operating with technology in the real world, then that could be the case. So yes, that's a helpful clarification to have made there. Can I patent an AI-based framework for software development? That's an interesting question that sort of perhaps sits a little bit between the system of a sort of fundamental AI system not applied to any particular technical field that I said could be a challenge for being deemed sort of too much just maths or abstract, and something that's more concrete and applied. But it would depend a bit on the details. But I think we would try to approach it that the field of the application of developing software is itself a technical process, and so this is an AI that is being used for a particular technical process. And so as long as it then meets the requirements of novelty and inventive step, then potentially that could be patentable. It may come a little bit close to the last answer I was giving, if it's simply automating how a human software developer worked in a sort of in terms of, you could in theory have done it on pen and paper, then that could be more of a challenge on whether there's a technical inventive step there at the European Patent Office. But it would certainly be worth looking at in more detail. Slightly longer questions to read here, bear with me a moment. So I guess anyone could argue that the mere idea of applying machine learning to a problem could tick off any machine learning solution claiming that any human with enough time could perform it as well as a machine learning solution. What has to be a clear difference to validate a proposed AI patent? So that comes a little bit close to what I was saying before. I think that if I've understood correctly, that it does depend whether the problem is inherently a technical one or a non-technical one. So maybe I didn't make that clear enough in the presentation. So that's a helpful clarification to make. If it's a fundamentally technical problem, then that wouldn't be seen as just a mere idea. It is potentially a technical invention. What's harder is if it's more of a business or sort of data management problem that's being solved, then that's where it could be seen as merely applying it to a problem that's been approached in other ways in the past. Although if it's a conventional machine learning system that's being applied to even to a technical problem, but one in a way that is seen as relatively obvious, similar to other related problems in the past, then it may struggle on inventive step, even though it may not be excluded on a sort of subject matter grounds. The point about having enough time, that is taken into account. So you're not simply automating a mental process if it's something that's just clearly infeasible for a human to do in a lifetime of work. There is some sort of reasonableness applied there. How are we doing on time? Yeah. What do I think? Is there also a risk that patent attorneys and patent examiners of the future may be AI systems? That's an interesting one. I guess there is that possibility in the very far future. I suspect that there are going to be more imminent automation and problem issues that are going to be affecting sooner than that, but I would never want to rule it out. I think the fact that patent attorneys, we are sort of by definition dealing with innovation, something that's never been done before, and trying to find a way to define in language a new concept, is one that is likely to tax AI systems for a while. It's not every patent is sort of bespoke, as it were, is different, is unlike any other patent, because you as the inventors are coming up with things that are different, hopefully, from anything that's been done before. But I wouldn't, yeah, certainly wouldn't rule it out. Certainly some of the formalities examination that the Patent Office does of checking that all the forms are provided and all the claims are numbered correctly, and some of these that terms are used consistently throughout the patent, and there may be tools that could help in the preparation process as well. But yeah, who knows? I think one day maybe all of us will have a lot more leisure time, and machines will be doing running the world. But I think the problem of general intelligence may have to be solved a bit better first, and I think we're quite a long way from that at the moment. My understanding, artificial intelligence really is still taking off in specific problems, more special intelligence rather than this generalized intelligence like Alan Turing's test maybe working towards more. Why did the Davis applications fail? Those were the ones that named a machine, the Davis AI system, as the inventor. It was basically on the simple procedural sort of legal point that a patent application must name a human inventor, and so the patent offices simply said you've run out of time for naming who the human inventor is, so we're not accepting them. I think the US Patent Office did put a note about it that sort of opened a little bit more about whether in the future that there may be scope for non-human inventors, and certainly within the legal profession and within academia, it's raised a lot of discussion about machine inventors. There have been similar issues raised perhaps in the past. There was an ape that took some photographs a few years back, you might have seen, and there was a question about whether copyright could be owned by the ape, was a gorilla or chimpanzee, and so yeah, the legal world has sort of had to wrestle with some of these issues a bit before, but at the moment humans are still seen as central, and inventions need to be owned by an individual or a company, and it's probably still at the moment thinking more about who controls the AI system that came up with the innovation, so it's more seen as a tool to help with AI, but that may have to change in future. Can image recognition and analysis, e.g. diagnosis of a disease by visual examination by a doctor, be deemed technical or non-technical problem? That's an interesting one. I'm not sure if it was intentional or not, but it touches on another field that I haven't mentioned before of excluded subject matter in some countries, which is to do with medical diagnosis and treatment. Some countries, including the European Patent Office, have rules in place to try and avoid patents restricting the freedom of physicians to treat patients. And so this could run into some of those issues as well. But a computer system that analyzes scans to try and diagnose a disease isn't fundamentally going to be seen as non-technical. That would be seen as a technical problem, because it's processing sort of pixels or voxels of data as bits and bytes in the system, and that's generally been seen as being something technical. There is a slight quirk that the European Patent Office, for some reason, has decided that analyzing text and trying to understand language in text is non-technical, but analyzing images is technical, and it's an inconsistency that I think has baffled some people. But yeah, image recognition should be seen as technical in general. It does still, of course, need to be seen as novel and inventive. I'm just having an eye to time here. I'm thinking we should probably wrap up. There are quite a number of questions that I see we haven't yet had time to approach. There's one here about cost? Are AI patents more expensive in terms of different rules in different countries? It depends compared with what. If it's compared with a sort of a more straightforward sort of mechanical invention, a new type of beer bottle opener or something, then it is likely to take more time to write the patent application and to consider all of the different angles and try and include enough wording in there to make it work in different jurisdictions, and to potentially try and future-proof it, because the law is evolving even as the patent is examined, and then for the 20 years or so that it might last, case law might develop. So to try and anticipate those things in this field will involve a bit more work, but it's probably still within the same sort of ballpark as other software patents, or potentially other patents in fields of biochemistry or pharmaceuticals, which can be quite lengthy and involved. In terms of the examination process, again, there may be some extra costs if rejections are raised that need to be dealt with, but that will depend a bit on the specific cases. And of course, any patent, even for a corkscrew for the wine bottle, could potentially face a lot of objections on novelty and inventive step that need to be dealt with. So it's hard to say as a sort of general rule that it would be more expensive. But the drafting stage probably is going to be at the sort of the more on the upper level, just because of the time that's needed. One question: is a method for generating metadata with a data set patentable? I think I might need to take that one up on both with time and there are a few others by email afterwards. So apologies if I haven't had time to do it now, but I will try and follow up with all of those afterwards. Yeah, thank you very much for your attending, and I hope you found some interesting things in there. And I'll just briefly hand over to my colleague Michelle to wrap things up. So over to you, Michelle.